What are the punishments for felonies under Nevada law? I'm going to walk through each and every category of a felony under Nevada law. It is very straightforward. Therefore, check out the whiteboard. So, penalties of felonies under Nevada law can be found in NRS Chapter 193. It boils down from Category A felonies all the way down to Category E felonies. So, A, B, C, D, and E. Basically, A is the most serious and B is the least serious. Nevertheless, a felony is serious overall. I'm just expressing that the punishments get more serious when you rise to the A category versus the E category. Therefore, let me explain each and every category one at a time. With Category A felonies, that's basically your murders, your sexual assaults, that field of things is where a Category A felony comes in, and that's where the death penalty comes in, or life in prison with or without parole. As sentencing, the judge to make that determination, obviously, but what I'm trying to say is that that is the max penalty for a Category A felony. Therefore, that is what boils down to this kind of category. Furthermore, for Category B felonies, those are your robberies, your burglaries, battery with a deadly weapon, assault with a deadly weapon. That's where Category B felonies come in. So it can be 1 to 20 years, but depending by statute, the statute that someone is charged with on a criminal complaint or their information will actually say on the piece of paper what category they're charged with. And the person can't look at this list, that's true, but different crimes have different minimums and max in terms of the penalty. So some crimes can be 1 to 6 years, the Category B felonies. But in this case, there are Category B felonies that exist under Nevada law that could be up to 20 years in prison. Therefore, that is a big thing that people should watch out for, or lawyers should watch out for when representing clients. That, hey, look at the statute. It'll tell you particularly right there, instead of criminality in general. But, like I just said, it's possible to have a felony, Category B, that has this max penalty. Furthermore, with Category C felonies, 1 to 5 years. Just in general, 1 to 5 years at the NDOC plus a $10,000 fine, which again, the 10 grand here is the max. Depending on statute, the statute itself, and this is why you got to be careful when looking at a criminal complaint or information, you have to look at the statute. Read the statute, it will tell you the fine, because sometimes it will depend on the statute. But just in general, because last statutes will just say, look at NRS 193. That's literally what it will say when you look it up. So a lot of the time, it will say, look it up, 193, this is it. 1 to 5, 10 grand max fine, and that'll be the situation for that client. Furthermore, with Category D felonies, again, with D's and E's, that's more possession of controlled substance, basically when someone has possession of drugs, right? And it basically leads to the felony land of things, right? That's just an example. So D's and E's, most famously for drug possession, 1 to 4 years plus $5,000 fine. But like I just said earlier, with the 10 grand fine for Category C's, is that look at the statute, read the statute. A lot of time it will cite to 193, and there you go. Your answer is basically right here in front of your face, right? For the Category D felony on a criminal complaint or the information, at least 1 year, at most 4 years in prison, plus a $5,000 fine. Lastly, with Category E felonies, the least serious, still serious, but the least serious among the felonies in this list will be 1 to 4 years in prison, and the court shall suspend the sentence and grant probation to the defendant with certain conditions. And sometimes those conditions under this statute can be 1 year at the county jail plus a max of $5,000 as a fine for the defendant. A lot of time, first-time offenders will get probation, no jail time. Obviously, if they mess up their probation, guess where they're going? They're going to prison. That's where the 1 to 4 years comes in. So basically, when the court shall, the word shall, not may, but shall, suspend a sentence, means that the defendant will be put on probation with conditions. And if they mess up those conditions, let's say they test dirty or they commit a new crime, whatever the case may be, then the suspended sentence of the 1 to 4 years, whatever the agreement is with the district attorney, basically the suspended sentence will kick in and the defendant will go to prison. So that is the penalties for all felonies under Nevada law that vary from Category A all the way to Category E felonies.